All right. Well, welcome everyone to our second Innovation Business and Law Center talk of the semester. I'm super excited to have Professor Jacob Sherkow here to speak today, to be talking about genomics and trade secrets. We actually had Jake speak about almost a year and a half at the start of the pandemic as part of our series on COVID-19 and innovation. So I'm really glad for him to be here in person and live. I'm just going to give a really brief introduction of him. So Jacob Sherkow is professor of law at the University of Illinois College of Law, an affiliate of the Carl R. Woese Institute for Genomic Biology at the University of Illinois, where his research focuses on the legal and ethical implications of advanced biotechnologies, especially as they relate to intellectual property. He's a leading expert on intellectual property protection for genome and editing technologies, including CRISPR, and the author of over 60 articles published in both scientific journals and traditional law reviews, including Science, Nature, JAMA, the Yale Law Journal, and the Stanford Law Review. From 2018 to 2021, he was appointed to the National Academy of Medicine as an emerging leader in health and medicine scholar, and currently serves as an academic advisor to the Academy's Committee on Emerging Science, Technology, and Innovation. Jacob also serves on the editorial board of a peer-reviewed scientific journal, the CRISPR Journal. His scholarship has won multiple prizes, including the 2018 Otto L. Walter Distinguished Writing Award. He's been a frequent commentator on patent matters in popular media outlets such as the Wall Street Journal, the New York Times, the Los Angeles Times, and NPR. Immediately prior to joining Illinois, Professor Sherkow was the Edmund J. Safra Petrie Flom Center's Joint Fellow in Residence at Harvard University and Professor of Law at the Innovation Center for Law and Technology at New York Law School. Professor Sherkow has also held visiting academic positions at Stanford Law School and Columbia University's Mailman School of Public Health. Professor Sherkow was a patent litigator at Gibson, Dunn & Crutcher and a law clerk at the U.S. District Court for the Eastern District of New York. In addition to his legal training, Professor Sherkow has several years of experience as a research scientist in molecular biology, is a certified editor in the life sciences, and is an avid squash player. So welcome, Professor Sherkow.
Thank you. Thanks, Jason. Thanks so much for having me. And thank you all for coming here today. I'm just going to launch right into it. My goal for this talk today, my first goal for this talk today is that it is entertaining. If it's not entertaining, then I have otherwise failed. But also, not so much that I'm going to convince you that genomic data are not trade secrets, but that you can at least come away with this thinking, okay, interesting, but wrong, as opposed to you are insane, right? So are genomic data trade secrets? Well, at least 2 decades of scholarship has essentially assumed so. The reality, though, is that in fact, there's been very few reported decisions directly on point and virtually no explicit statutory authority. More importantly, I think for purposes of this talk, though, if you actually go through and you read the pertinent statutes, right, and I think here, because trade secrecy is a creature of both federal and state law, this taking a look at both the Federal Defend Trade Secrets Act, as well as our Uniform Trade Secrets Act adopted by many states. If you actually go through and you take an investigation of the statute, and you read it in light of advances, recent advances in genomic technology, I think the answer comes out to be no, right? If you know anything about this field, this is the point of the talk where you should go, wait a second, really? Like, that is an absolutely crazy thesis. People have been saying that genomic data has been subject to trade secrecy protection for 30 years. The best legal minds on the planet have think that it is so. Scientists in the upper echelons of their field have proceeded with the assumption that this is the case. Who are you to come along and say that everybody has been doing it wrong, right? So let me start off, I think, by explaining where this comes from, right? This comes from an understanding of the rise of genomic data from the past 20 years, right? This is the launching point for my provocation today, right? Essentially, prior to 2001, DNA sequencing was particularly costly, uncertain, and difficult. It was conducted through a method known as Sanger sequencing, which is essentially just individually reading out base by base a sequence of a particular gene. This, while it was a high fidelity process, was something that really was difficult to be routinized or automated, right? Through this process, through this incredibly costly, difficult, expensive process, this is essentially the technology that yielded our Human Genome Project. That is the effort to sequence every single gene otherwise within the human genome. Our Human Genome Project is completed. This is the point of the talk where I think it makes sense to use air quotes, right? It was completed in 2001, although the reality is that it was really only mostly finally completed in 2004. There's actually bits of the genome that we're still uncertain about today, right? But in 2001, when our Human Genome Project is otherwise finished, the reference genome, that is a general idea about which genes are in the human genome, starts to make sequencing a lot easier. And then there comes a huge technological development circa about 2005. In 2005, a company called Solexa, which has since been acquired or has become essentially the DNA and genome sequencing juggernaut that is Illumina today, develops the first iteration of what's called next generation sequencing technology. This next generation sequencing technology, at least back then in 2005, centers on a method known as sequencing by synthesis. You take a large chunk of the human genome, you essentially fraction it into tiny little bits, you repeatedly sequence those tiny little bits, and using a computer, you stitch them all back together, right? This was an incredibly monumental moment in the universe of genomic sequencing that has essentially given rise to the ease and the ubiquity of genome sequencing that we've otherwise seen today. So a little bit about that, because I think it's fun, right? Today, far, far, far from being costly, uncertain, and difficult, obtaining DNA sequences, and for that matter, genomic data of all stripes, is cheap, it is accurate, it is easy, and it is fast. And to give you a sense about just how much cheaper it has gotten, not just since the Human Genome Project, but since the development of next generation sequencing technology. Here is 2005, this is 2006, if I'm lining this up correctly here. And you could see that the price, the cost of sequencing genomic data per base, like per individual letter of the genome, or A's or C's or T's and or G's, has just rapidly dropped off a cliff here, right? This is, let's take a look here, 1, 2, 3, 4, 5, 6, 7 orders of magnitude cheaper than it was only since back in 2001. All right, this is like a great graph that some economist or some tax policy wonk would otherwise use. But what does this mean for your day-to-day life? Well, today, rather than costing $10 billion to sequence your genome, that's how much our Human Genome Project cost in its initial outlay, you can get your own genome sequenced for $299 retail from Nebula Genomics, on sale now, right? Run, don't walk, right? Not only that, but the genome sequencing that's being conducted here at the retail level now is actually at a higher fidelity than the Human Genome Project otherwise was. One way of reading the fidelity of any genome sequencing project is by how many times coverage, like how many times for each individual sequence does the sequencing machine read. Generally speaking, for most purposes, 30x coverage is considered excellent, and that's what's otherwise being sold here. But if you want 1000x coverage, if you really want some high fidelity sequencing, well, let me try to upsell you here for our ultra deep genome sequencing here for $999, right? This is something that you can otherwise get done today. In addition, the Human Genome Project was not something that happened overnight. It was a research project that took decades and decades to complete, roughly speaking, about 20 years from start to finish. That is from our first base sequence until we have this 2001 draft sequence otherwise available, right? How quick could it be done today? Well, our current record as of February 17th, 2022, 7 hours and 18 minutes. And that's not just 7 hours and 18 minutes of sequencing time. Here's what that 7 hours and 18 minutes otherwise yields, right? A patient coming into a hospital setting with an unknown illness, the clinicians taking a sample from that patient, running that sample down to the sequencing lab, conducting whole genome sequencing, making a diagnosis, and returning that diagnosis back to the patient. That did not take 20 years. That took 7 hours and 18 minutes, roughly speaking, about the time it takes to fly cross country if you include like getting to the airport and going through security and getting a bite to eat and stuff like that. That's essentially how long it takes now. Not only that, but we're not only conducting sequencing a lot cheaper and a lot easier before, we are so utterly awash in genomic sequencing data that we are using it for completely ludicrous and trivial purposes, right? I will give you just 2 examples here. First example, to the extent that you have been on the internet in the past, I don't know, 2 years, you have probably been ad served with something that goes like this. MIT grads discover a method to figure out which wine you like. By the way, footnote here, the answer is all of them, right? Anyway, right? The basis for this is that you are going to essentially get genome sequenced through this particular company, right? And in theory, they're going to try to figure out what types of flavors you may otherwise be predisposed to and match that to a wine varietal, right? Or perhaps instead of liking wine, you like international travel. And so luckily for you, for a while, this has since been discontinued, right? But for a while, Aeromexico, Mexico's national airline carrier, was offering a service where you could get genome sequenced with them, right? And depending upon your quote unquote percentage of Mexican ancestry, you would get a particular discount. That is, in theory, the more Mexican ancestry you had, the greater your discount would otherwise be. Once more, with feeling, this is a genome service being offered by an airline to trade it in for coupons. Also, worth noting, neither of these things actually work. But the point of this is it's so cheap and easy to do the sequencing, the companies who are running this that otherwise are not in the business usually of genomically sequencing their customers are indifferent to actually doing the sequencing technology itself, right? All right, pretty cheap, pretty easy. We're awash today in genomic data. We use it for stuff both real, clinical care, and not real, deciding whether to go with the Pinot or the Merlot, right? All right, and yet, a raft of legal scholarship has been underwritten on the premise that genomic data are, by and large, protectable by trade secrecy. I think a closer examination of that work, however, uncovers a couple of curious facets of this assumption. The first facet is that almost all of scholarship making these claims essentially focuses exclusively on a single example. And that single example is Myriad Genetics database covering BRCA1 and BRCA2 genes. These are the genes subject to the 2013 patent dispute for the US Supreme Court that are also implicated in some particularly vicious early onset breast and ovarian cancers, right? But 2 things to think about. First thing to think about is that, like I've mentioned before, those genes get sequenced. This database essentially gets started, although it obviously has continuously been updated, gets started back in 1994, which from the genomic sequencing perspective is essentially the Stone Ages, right? In addition, one of the things that makes Myriad Genetics database value is, in fact, not just the raw genomic information, but the fact that it has been paired with other functional information out there, namely patients who have gone through Myriad Genetics sequencing and have also received clinical care. One is not necessarily valuable without the other. Scholarship, for the most part, has essentially not focused on either of these, though there's a couple of scholars who have said something to this extent, but certainly they're in the minority position of people who are focusing in this particular area. The other thing that I find to be interesting about scholarship in this field is like, there really seems to be little engagement or skepticism of some of the elements of trade secrecy, which I'm going to go through in a moment here, right? Rather than saying, here's what the elements of trade secrecy are, and here's why I think genomic data otherwise apply to them, you get these statements in a lot of law review articles that genomic data are subject to trade secrecy, footnote, see the Uniform Trade Secrecy Act. That's it, right? No real analysis about what's going on under the hood and why we should otherwise assume that this bit of data otherwise meets the statute's strictures. In addition, there's been quite little engagement with this rise of sequencing data otherwise out there. There's a lot of genomic trade secrecy literature that seems to be predicated of genome sequencing being costly and difficult and expensive, essentially back to the days when the only tool we had to do this was Sanger sequencing. No longer true anymore. Not only do we have the Illumina technology that I mentioned earlier, there's a bunch of next generation genome sequencing technologies that have since come online, right? All right, you're still skeptical, I can tell. It's not just being tired after lunch, right? And so you may be thinking to yourself, all right, so fine, like there's some, not awesome law review articles about this. What do I really care? Like it doesn't really move the needle for me that much. Well, maybe what we want to see instead is cases. Like we want to see cases that are litigated, and that's going to tell us whether or not genomic data are trade secrets, right? Well, if you actually go through Westlaw or Lexis and you look for cases that make an explicit statement as to whether genomic data themselves are subject to trade secrecy protection, there is an astonishing paucity of cases. Roughly speaking, about 24 unique lawsuits, depending upon how you count what a unique lawsuit is, right? Just a really, really low number, especially compared to the general number of trade secrecy cases that get filed every year, and especially relative to the number of other intellectual property cases that get filed every year. In addition, none, zero, as far as I can tell, and you are welcome to look, right? Zero, as far as I can tell, address this rise in genome sequencing that I have mentioned earlier. None seem to recognize the shift between the days of non-automated Sanger sequencing and the days of Illumina dominating the sequencing market with their SBS technology, right? In addition, some of these 24 cases that otherwise state, right, genomic data is protectable by trade secrecy, right? Some of them are pretty idiosyncratic, right? And so just to give you a flavor of some of these idiosyncrasies, I would like to talk about my favorite genomic data trade secrecy case, North American Deer Registry, Inc. versus DNA Solutions, right? All right, what's going on here, right? North American DNA Registry versus Deer Solutions. North American Deer Registry sought to build a lineage database for buck semen, right? There is a market to breed bucks of certain lineage, right? And so they decided to develop this genetic database of just that. Well, why would people care? Well, this would allow purchasers to identify who the parents of the buck that they otherwise want to create came from, right? These are called straws. I don't know if anybody is in the deer breeding business or not. And anyway, okay. The defendant, DNA Solutions, right, takes portions of this database in confidence, and the Eastern District of Texas issues a preliminary injunction, right? It issues a preliminary injunction on the grounds that North American Deer Registry's genomic database is protectable by a trade secret, right? But here's where things get interesting, right? In doing so, the court rejected DNA Solutions' argument that the database was not a trade secret and that the biological material and genetic data itself was the thing that created trade secrecy protection. Rather, the court finds that instead, only the entirety of the database, that is both the genetic information and the lineage map, right, was protectable by a trade secret. Indeed, the plaintiff's own expert testified, right? This is in theory, the trade secret holder, right, had an expert who testified that the economic value, and I'm just quoting directly, the economic value of the registry flows from the deer lineages, not the genomic information, right? The court agrees with this statement and so issues its preliminary injunction, right? All right. Here's why this gets even more interesting, right? This database was created back in 2007, which, if you remember, is just in the nascent days of our rise of sequencing by synthesis technology, the next generation sequencing revolution that we've otherwise had. But today, it seems like it's just kind of meaningless. Today, right, breeding lineage sequencing costs retail about $300, a price, by the way, that will be discounted by many breeders to absolute zero if you are willing to pay stud fees. In other words, you're willing to pay stud fees, they're going to give you the lineage map for nothing, right? I want to take a step back for this for a moment, right? This is not just an entire lunch lecture about the, ungulate breeding business, right? But that the vagaries and business model of deer breeding are probably don't stand for a generalizable proposition that genomic data are trade secrets, right? All right, fine. So the case is not super informative, you may think, whether genomic data are trade secrets or not, right? Well, what about this statute, right? And this is where I really think the rubber hits the road, right? What is a trade secret, and why do I think that the elements don't otherwise meet it? Well, trade secrets constitute information, generally speaking, that pose several core elements, right? The first is that they're subject to reasonable efforts to maintain their secrecy, right? If I go through reasonable efforts to maintain some information as being secret, that's one of the requirements for that information to be considered to be a trade secret. Second element is that the information itself cannot be readily ascertainable to the public. And a third element is that the information needs to, and this is critical, derive independent economic value from it being secret, right? All right, so first things first, granted, some holders of genomic information may be subjecting that information to reasonable efforts to maintain their secrecy. They put it behind a server for which there's not otherwise access. They try, like a North American deer registry, to sign non-disclosure agreements to make sure that people don't otherwise share their information. Fine, right? I think we've otherwise met that element. But is it necessarily true, right, that this information is no longer readily ascertainable to the public, right? Well, you take a look at some of the ready ascertainment cases, right? They're a source of significant dispute in the courts, right? Courts have primarily homed in on the effort or the expense in recreating the information. Information that is, quote, easy or, quote, economically feasible to discover from its original source has been considered to be readily ascertainable for trade secrecy purposes, right? Here's a couple of examples of those, right? Combing the prior literature for components of the alleged trade secret, building one's own database from public information, or even hiring those with experience in the field to recreate information that otherwise has been locked away. These are all, in my estimation, greater efforts to uncover the trade secret than simply sending off somebody's spit samples to Nebula Genomics, right? For fractions of a penny on the dollar, right? All right. Well, what about deriving independent economic value from its being secret, right? Well, to any genomicist out there, right, just like North American Deer Registry teaches us, just like the Myriad Genetics database teaches us, right, the genomic data itself not only is not valuable, it's otherwise meaningless, right? Its only value is in concert with other information. And even then, genomic data that is created today, even in commercially lucrative fields like immunology or drug development, is routinely dumped online en masse for public use for free in the hope that it could be aggregated with other data out there to bring it value. This is in fact the basis of a lot of genomics research consortiums out there, such as the Structural Genomics Research Consortium, the Cancer Genomics Consortium, the Adaptive Immune Receptor Repertoire Community, just to name a few, right? All of which recognize that these genomic sequences standing alone are not valuable as secrets, but are pre-competitive data that are improved, the value of which is improved when they're combined with other data out there, right? This strongly suggests that I think a lot of genomic data that we otherwise have, in fact, does not derive independent economic value from it being secret. It is actually worth more when it is disclosed. Right? Okay. This was fun, right? But like, so what? Who cares? Like, I get it, you know, genomic data, maybe it's not trade secrets. I don't really care. Why should I care, right? All right. So here's why I think it's important, right? I think there's some practical consequences, some of which are important. And then to the extent you're a trade secrecy scholar, other than just simply telling you like everything that you've been doing is wrong, which I think is a really fun sport, right? I think it also may inform some of the greater things we may think about trade secrecy generally, right? So let me start off with some of the practical consequences, right? Practically, right? This means that the unauthorized disclosure of genomic data or DNA sequences, it can't give rise to a misappropriation claim, right? You can only misappropriate a trade secret, not a de facto one, right? This seems to preempt the possibility of claims in a variety of venues, right? Courts, both state and federal, for example, can't bring a trade secrecy claim, if I'm right, right? Section 337 claims before the ITC predicated on trade secrecy protection can't bring those and prevent their importation into the United States, right? I want to be clear about this, right? The disclosure of secret information could otherwise violate duties of confidentiality or fiduciary duties or some other form of trust. But importantly, the causes of action for those claims tend to be substantially narrower and have substantially lower penalties. The harm for such cases is the harm to the information holder, not the harm from the diminishment of the value of information. Furthermore, to the extent that the cause of action you're being tagged with is a violation of confidence, it is unlikely the plaintiff is going to be able to get equitable relief to prevent you from further disseminating that information. The remedies for these confidence violations typically seek to both compensate the information holder and punish the bad actor, not from an equitable perspective, try to put the toothpaste back in the tube, right? I think also the absence of trade secrecy protection for genomic data may serve as an explanation for why we have so few cases out there, right? Litigants, when push comes to shove and they've actually kind of walked through the math with their attorneys about, are we going to get a trade secret misappropriation claim on the books? Their attorneys may have gotten cold feet. They may have been gotten cold feet because they went through the same analysis that I otherwise went through, right? All right. The second practical consequence of this is that without trade secrecy protection, I think we're likely to see a confidentiality arms race for holders of genomic data, right? Without trade secrecy or some other form of IP protection, the holder of sought to be secret genomic information would need to rely on de facto protection, either legally, like we're just going to make everybody sign an NDA, or we're going to obfuscate the information we otherwise have, or technologically, like, for example, through encryption. A lot of work being done right now on genomic data encryption, I think, because there's some recognition that trade secrecy protection may not be as strong as everyone otherwise thought that it was going to be. This would potentially encourage holders of genomic information to expend outsized resources on maintaining such secrecy. So in a world that's otherwise reliant on the sharing of genomic information, this could potentially be problematic, right? Third, I think that this understanding of genomic data as not being protectable by trade secrets, like it takes the bite out of confidentiality protections otherwise on the books. It threatens the non-disclosure agreements that are predicated on such information being protectable by trade secrecy, right? Or therefore allowing licensees of this information to access or recompile or distribute the data only on the penalty of this violation of confidence, right? It also, in some circumstances, relieves licensees of biological material under an archetyped material transfer agreement. This is the UBMTA, the Uniform Biologic Material Transfer Agreement, right? From the agreement's most serious shortcoming, right? And that is its lack of a license to the material's trade secrets or proprietary rights, right? To the extent that you have biologic material and it's just not protectable by a trade secret, right? The UBMTA doesn't really do you a whole lot of work, right? And also possibly maybe it devalues such information as non-public or confidential business information under some of the regulations of a number of agencies, including FDA and the National Institutes of Health. Right? These are some of the practical consequences of this, if you believe me, right? There's some theoretical consequences too, like, if you're a trade secret scholar, right? The absence of trade secrecy protection for genomic data, I think it undermines this dogma of the patent trade secrecy trade-off. Essentially, everything I've said today is just absolute heresy, right? The dogma is that inventors get to choose between patent or trade secrecy protection and have to essentially make this election relatively contemporaneous with when the information is created. But what if neither is available, right? Genomic data, such as it is largely now unpatentable in the United States, post our Myriad Genetics Supreme Court case that I mentioned earlier. And if I'm right, then it looks like it's also not protectable by trade secrecy. And so I think that understanding some of these things suggests that the competing regimes are actually not a trade-off, but are mutually unavailable. And if they're mutually unavailable, that just seems like a raw policy preference, one that we should at least be honest about, right? We should stop calling it a trade-off. We're just like, we don't want to protect this stuff, period, full stop, end of story, right? Finding that genomic data is not protectable by a trade secret, I think it also extends some of the current literature on an area known as trade secrecy abandonment to what I'm calling trade secrecy termination, right? All right. So trade secrecy abandonment occurs when the trade secret holder no longer derives economic value from the secret information by, for example, replacing a product that embodies a secret information with a new one that doesn't, or otherwise exiting the market entirely. This is a paper came out a few years ago by Camilla Hurdy and Mark Lemley that essentially went through exactly what this doctrine means. But trade secrecy abandonment, just like abandonment in real property, right, or property, right, focuses on the conduct of the property holder, right? Generally speaking, what the property holder does in order to relieve themselves of the thing that they otherwise own, right? Secret genomic information, by contrast, may no longer derive independent economic value from its secrecy for reasons having nothing to do with what the holder of the trade secrecy does, but rather because of changing technological and societal conditions out there, right? I think one good analogy actually comes from your first-year property context, and this is essentially changing conditions doctrine in the servitude context, right? We're going to say that a servitude is otherwise extinguished if changing conditions on the ground make it impossible to accomplish. Well, we can say that a trade secret could be terminated here if changing conditions on the ground, independent of what the trade secret holder wants, right, have made it impossible to derive independent economic value from its secrecy. Last, I think that traditional accounts of the absence of protectability of such research products suggest that they're going to be underproduced, right? But for genomic data, this seems like the opposite, right? If it's true that genomic data is not protectable by a trade secret, well, we've seen an explosion in genomic data out there. Like, what gives, right? I think this is actually a story about when and under what circumstances commons resources get created, right? Which you may think is counterintuitive. We've removed the protectability of something and now we are creating more of it, right? But I think it's actually a story about what happens when we have a piece of information that is improved by its disclosure rather than its secrecy. This would suggest, if this is in fact true, that whether you agree with the descriptive argument that genomic data is not protectable by trade secrecy protection, that at least trade secrecy is a bad policy. If it's true that we get more genomic data, the less protection than we have, right? Well, we should start getting rid of a lot of protections, right? Okay. Not so fast, right? All right. I'm trying to upend like 30 years of everyone's understanding of the way that this stuff works. And so I realize we're getting close to the afternoon, but you shouldn't be so suckered in by everything that I'm otherwise saying, right? Here are some counter arguments, right? To make you think that what I'm saying just can't be correct, right? First of all, like I said, this cuts against decades of scholarship and common understanding in the area. Who am I to have figured all this stuff out? Can't just be me, right? Second of all, fine. I get you about the ready ascertainment point, but cheap and easy doesn't mean ready ascertainment. Ready ascertainment is a super low bar, and spending $300 to get someone a whole genome sequence just doesn't meet that period, full stop, end of story. And last, or second to last, right? Like you said earlier, when it comes to the myriad genomic database, right? Like it's valuable, right? Well, you know, fine. So it's valuable when it's combined with other stuff. Who cares, right? We don't really care whether the genomic data itself is protectable, but it's combined with something else, and that becomes valuable, then that's a trade secret, and that's just what people are going to do, right? Last counter argument, right? Look, other areas of trade secrecy really have a low number of cases, and nobody's dumping on them, right? So why should we care that we have so few genomic trade secrecy cases out there here, right? Okay, well, fair enough, right? But here's some counter arguments to the counter arguments, right? All right, first of all, this cuts against decades of scholarship in this area. Guilty, right? That's what makes this talk fun, right? But the reality, as I mentioned earlier, is like no one has done the analysis. No one has really grappled with where genomics are now situated post this revolution in sequencing by synthesis technology. It does not seem to show up in the literature in the places that you would otherwise expect it to show up. So perhaps that I am wrong, but someone's actually got to do the grunt work to figure out whether this is true or not. All right, cheap and easy doesn't mean readily ascertainable. Maybe not, right? We have some cases in which some really easy to obtain information is otherwise not readily ascertainable. But if you take a look at the restatement, the standard for ready ascertainment under the restatement is something that is not difficult, costly, or time consuming. And hopefully, at a minimum, what I've shown you today is that genomic sequencing is not difficult, it is not costly, and it is no longer time consuming. So if we're going to take the restatement's definition of what ready ascertainment means on its face, then I don't think genomic sequencing meets the standard, right? All right, what about this combination point? All right, yeah, but that's kind of my point to begin with, right? Like genomic information is not as valuable as you think that it is. And for that reason, it is not protectable alone. It is really only as good as the identifiers we otherwise use to pair it with. And if we've got really excellent identifiers, then it is that rather than genomic data that makes the trade secret that we're otherwise concerned with. Last, other areas of trade secret have a paucity cases, no one's dumping on them. Fine, right? That is just like a both sides argument, right? Maybe they're wrong too, right? Maybe those things you think are trade secrets because they don't have a bunch of litigated cases around them. Maybe they're not, right? And there are some other areas in the trade secrecy canon that do have a lot of robust cases, right? Designs for microchips, customer lists specifically of customers willing to purchase your product under certain conditions, economic models, real technological innovations, right? These don't seem to really be analogous to some of the genomic data that we otherwise have, right? All right, so hopefully this provocation was fun to you and has given you a couple things to noodle on. So what should we do about it to the extent that you believe me, right? Well, maybe nothing, right? Like, are things really so bad now? Like I mentioned earlier, we're awash in a universe of genomic information, and genomic technological development is proceeding apace, right? The state of the world, at least with respect to genomic information, is not so horrific. So maybe we shouldn't do anything. The flip side of not doing anything is that we shouldn't affirmatively do bad stuff, right? And that's essentially these things here, right? So first things first, there is some talk on the ground of like, we're entering into a new age of biology. We should otherwise enumerate special protections for genomic data. Maybe we should not do that, right? Maybe just the mere recognition that this stuff is not a trade secret is enough, right? In addition, Europe has a special sui generis intellectual property protection for databases themselves. I will note here that it is particularly narrow, but there is some talk that it should be adopted here in the United States. Well, if things really aren't so bad now, maybe we just shouldn't be doing that either, right? This kind of cuts against some of the policy implementations that are being discussed at the moment. Last, post the Myriad Genetics Supreme Court case, there's been some discussion about finding ways of reclaiming genomic information as being patent protectable. And if I'm saying they're not trade secret, and if you believe in the trade-off thing, right, well, maybe we should make them patent protectable again, right? I would say maybe not, right? Don't order patent rights to include them if the current state of affairs is really not so bad. On the more practical side, right, some advice to attorneys is like, to the extent that you have contracts that deal with trade secrecy in the genomic context, boy, if I were you, I would go through them. I would not make the assumption that simply because somebody has genomic information of yours in confidence, that that is necessarily a trade secret, right? And what you want, obviously, is the full suite of remedies, not just the ones for the violation of fiduciary duty claim, right? To the extent that you're a judge litigating these trade secrecy cases, right? Like, you should actually do the analysis, just like our judge in the Eastern District of Texas, right? You should actually walk through whether or not the thing that is protectable is the genomic information or the database as an entirety, and exactly what that means. So actually go through the analysis, go through the elements, don't just make that assumption. All right, there you go. That is this crazy talk. I am done. It's been a delight to share this with you. Thank you so much for having me, and happy to take questions if there's time.
All right, we've got time for questions. If you're online, you can type your questions into the Q&A. I've got a couple in there already.
Oh, great. Good. Everyone's telling me that I'm nuts.
So,
perfect.
One question from Zoom is a clarification question. Why termination or extinguishment trade secrets does not exist for genomic data, although it's treated as confidential information? Analogy is to UK distinguish between confidential business information and trade secrets.
So why extinguishment or otherwise, right? So to the extent that they are currently considered to be trade secrets, right, which I essentially saying that's no longer true. But the extent that they're currently considered to be trade secrets, I think the question is what happens when they get easier and easier to ascertain, right? And if that's true, you got to think about like what the intervening event is that's causing them to end. I think one way of thinking about this is like termination, the way at least we here in the United States, right? Think about termination in the servitudes context, but I mean, I'm more than happy to entertain other analogies as well.
Another question from online, can you discuss a relationship between trade secret protection for genomic information and protection for other types of personal information like biometrics, personal purchasing patterns, and financial information?
Okay, right. So I would essentially just go through the same analysis for those that I otherwise went through for the genomic information that I had here. Biometrics is probably an otherwise better analogy. If you have access to a particular source, right, to a patient, right, or to someone who otherwise is willing to give up their biometric information, actually doing the analysis to get that the biometric information, really easy. Let's take facial recognition, right? Facial geometry, I think, is a really great example, right? Used to be a time not so long ago where if you really want to take someone's facial geometry, right, you needed relatively sophisticated like 3D scanners to do that, right? Not anymore, right? You guys have all plugged in your iPhone, you tag people in photos, right? This is like completely meaningless now. And so to the extent that there were previous databases that went through some of those facial scanning technology relative to what we have now, I would say some of the similar analysis applies, right? Technological innovations have at a minimum weakened the trade secrecy protection for some of that stuff. You want to contrast that though with financial information, right? This is information that may not necessarily be easy to obtain. It's not like you can like take someone's, take a picture of someone's face or, have someone spit in a tube and understand their entire financial history, right? Actually collating that information, especially from public sources, is incredibly difficult. This is one of the reasons why a lot of people who are collating financial information use private sources to do that. I would say that in those contexts, right, it's actually not like super readily, or at least some of it is not readily ascertainable. right? It's not readily ascertainable the way that some of this stuff is like facially, right, if you want to think of it that way, right, or with minimal technological intervention in the way that some financial data is. So I think in order to figure out whether this has met the ready ascertainment standard, you're going to kind of need to go through the specific technological mechanism that is needed to uncover the information that you otherwise want.
All right, so I have a question on the readily ascertainable.
Sure.
So a counter to your counter to your counter.
Yes. Yes.
Okay, so I want to recreate the deer buck thing, and you're telling me it's not difficult, costly, or time consuming.
Yes.
So there's maybe 1,000 bucks in the thing, maybe more, but 1,000 lineages. So it's $300 a pop. Great, I got my $30,000. I'm ready to sequence them all. I have to find 1,000 bucks. So why is it not $1,000, but 1,000 actual deer bucks?
Like $1,000, right? This is going to start getting confusing in a second, right? About like which buck we are referring to, right?
Yeah.
Yes, right?
Why isn't the access to
Sure.
the thing counted in? And I could say the same for Myriad. Part of what makes their genetic data valuable is that it's from thousands upon thousands of women and men, mostly women, who they've collected over time, right? So you can't just go out and find a bunch of breast cancer patients over decades.
Yeah, so really great question, right? This is something I plan on exploring in the full paper, right? I think these are two actually separate issues. The first issue is related to access. Like, am I going to get an equal crack at the subjects that make up the database as anybody else does? The second is scale, right? If we've got a database and it has like 30,000 people in it, maybe that's going to be different than if it's a database that has 30 or 300 people in it, right? So I'll start off with the scale one first, right? Yeah, I don't disagree. I think at some point, at some n, right, like having a database that is so enormous, right, may make it valuable because it would be like time consuming to do all of that sequencing, right? But the reality is that there's a lot of genomics database out there that have an n smaller than you would otherwise think. So some of the cancer genomic databases, especially some of the private ones, right, not some of the big ones by NIH that have, tens of thousands, in some cases, hundreds of thousands of patients, but some of the private ones which people pay access to, your n is in the hundreds. Your n is maybe in the thousands. And at some point, I think that's like kind of on the other side of the line of difficult, costly, or time consuming. So where one draws the line, like I think it's going to be a fact-by-fact determination on that particular case, but I'm not necessarily sure that that's specific to genomic data or just a virtue of databases generally speaking. On the access line, yes, you're right. Like, so to the extent that part of the information is like these 1,000 male deer, just to confuse, to avoid, bucks here, right? Like these 1,000 subjects constitute the database, and therefore I am not going to tell you from whom they came from, right? That, when combined with all the other information out there, could otherwise make information otherwise would not be protectable a trade secret, right? It's the information about where to go to, right, that makes that valuable. But again, in a lot of these genomics databases out there, we have a really excellent idea about exactly who constituted this database. And one of the interesting things about the world we live in today, right, is that reconstructing or attempts to reconstruct the Myriad database have in some cases been easier and other cases harder than I think people have imagined. They've, to a certain extent, been easier because people have identified themselves as being Myriad customers. Their healthcare providers have identified themselves as like purchasing Myriad's services, or they've otherwise put this information about undergoing these sequencing tests on social media, right? Information that's dumped and easily collected on social media about who's a Myriad customer, like, that's probably on the other side of the line of like difficult, costly, or time consuming. Is it going to be like a perfect recreation of the database? No, but at the same time that diminishes, again, the economic value of the database as a whole. So I think it's going to depend on the factual circumstances about access out there. 1,000 deer out of the 1,000,000 deer we have in the wild somewhere, maybe, right? Some subset of hundreds of patients who have identified themselves over a denominator of 1,000 patients, right? Like, probably not. Yeah, so again, I think it's going to be a fact-by-fact determination as to what constitutes access or not, and how easy it is to go about figuring out who constituted that database based on rights of access. So we got some questions. Yeah, please.
So jumping off of that point is, so I understand what you're saying about the sequencing front. It's cheap and easy. But my argument is the A, the G's, the T's, and the C's don't tell us much without annotations. And annotations of the genome are still very expensive and very hard to do, especially like enhancer regions or like transcriptomes or something like that. So I guess my argument is, what do you say that to people who say, yes, I understand sequencing by itself satisfies all those points, but the genetic data or the genomic data as you're talking about it now is primarily based upon annotations or research after sequencing, but it's still very expensive and very hard.
Right. Two thoughts about that, right? Thought number one, a lot of the annotations out there have been routinized, right? In other words, like, we've got a bunch of sequences. We want to know what the function of this particular gene is. How do we go about figuring that out, right? I mean, that's essentially what NIH's BLAST database does, right? So there's like a lot of annotations out there where if you do have a particular genomic sequence, like, you could readily figure out what it otherwise pertains to, right? That's the first point, right? The second point is, yeah, I agree with you. Coming up with new annotations is like incredibly valuable, right? But essentially, because the genomic information itself is otherwise meaningless, right? The genomic information becomes more valuable when you share it, precisely because the thing that you can do with it is make annotations. That doesn't make the underlying genomic information derive its independent economic value from its secrecy. The annotations derive independent economic value, but the underlying sequence, maybe not, right? So here's a really good, I think, right? Here's a really good example. If you want, like, some of the canonical trade secrecy cases out there deal with customer lists, right? And you can imagine this is otherwise difficult information to obtain. Who is most likely to buy your product? Well, the only way you can really figure that out is to get inside a bunch of people's heads, and it's really expensive to get inside a bunch of people's heads. Maybe this is frightening, but it's a lot easier to figure out what people's facial geometries and genomics are than to actually get inside their heads, right? And so you can imagine for a moment that you have a customer database out there that matches up the propensity to buy your particular product with the person's name and phone number, right? Well, to the extent that the phone number is publicly listed, right, the phone number does not derive independent economic value from its secrecy, right? It's readily ascertainable. It's easy to identify. It tells us nothing of importance of what the database does, right? It's still helpful, right? But it doesn't actually derive its independent economic value from its secrecy. And so depending upon what the annotations are that you're looking for, right, like the actual raw sequence data may be kind of similar, right? What you really want to do is you really want to line up annotation to subject. The genomic data is just the intermediary. Right? More questions?
I've got another provocative one. It's a good one.
Yeah,
Which is,
let's
does
do
the
it.
issue of private ownership of DNA, such as in the case of Henrietta Lacks, bear on the issues here?
Does the ownership of private, okay. Can you repeat it one more time? I just want to make sure I'm getting that clearly.
The issue of private ownership of DNA, right? Businesses owning
Sure.
information, DNA, such as in the case of Henrietta Lacks, bear on the issues here.
Yeah, right. So none of this would be possible, right? Like this whole debate wouldn't even happen to the extent that it's a debate. I mean, a debate assumes for a moment that like I'm on an equal playing field as everybody else, as opposed to like an entire body of work and me just screaming into the void, or not screaming, but laughing, right? But like this whole thing wouldn't really be possible unless we began with the operating assumption that if you create information, you can essentially make it private, right? Like it's like a, it has some private property value to it, right? And so like, I think to the extent that we wanted to live in a world in which that was the opposite, right? Like if you have genomic information, it must be shared. It is not allowed to be private property. Then yeah, this would just like, this would upend everything. Maybe we would get to the same point that we've gotten here in this talk, and to a certain extent, the human genome sequencing project's Bermuda principles kind of do that. The Bermuda principles for the Human Genome Project say if you're going to receive federal funding, you're going to do genome sequencing, you are obligated to dump your sequence information 24 hours upon completion, period, right? So the extent that's going to happen, like, yeah, maybe this stops being meaningful, right? I'm not entirely sure that has a lot of bearing, generally speaking, on the Henrietta Lacks case or the story, right? That was a case not about like genomic information and data, but like who actually owned the material that became the HeLa cell line, right? This is much more intangible. I think that the HeLa case is a lot more about tangible property. Cells, not information.
So just going one step forward there.
Sure.
So there's some states that do give individual ownership over their genetic data. And I think
Sure.
some are written broadly enough that it would include data, not just the good, right? I
Right.
think like Florida has one where
Right.
it's the good.
Yeah, that is, as I go past some colorful pictures here, that is this right here, right? There's almost no statutory authority, but where we do so on these state-specific laws, like Alaska, for example, and there's actually a case going on right now, right? I don't know if it's the District Alaska or whether it's in state court, but I have to look, right? About like, yes, there's going to be some protectable information about your, like you own your genomic information, there's some protectable information about that. So 2 ways of thinking about that, right? Way number one, right, is like, that is a belt and suspenders approach to genomic data being protected. And generally speaking, people don't wear belt and suspenders. So way number two of thinking about this, right, is that that information is otherwise not protectable, and what you needed was a specialized state statute to make it so, right? I think the second one is probably clear interpretation. Maybe, I don't know. I'm at least willing to entertain it.
One more question.
All right,
Don't be
I've
shy.
got one, which is,
Sure.
I'm not sure that you've done anything other than persuade me that genomic data is valueless. So why is genomic data
Great,
valuable?
Great, stop, let's stop. No, okay. No, sorry. Why is genomic data valuable? All right. Here's a glib, stupid answer, and then maybe a more robust answer, right? All right, here's the glib, stupid answer. Because some people says that it is, right? Like, why are NFTs valuable, right? They're not. You've all been fooled, right? Just because someone says they're valuable doesn't make them valuable. I don't care how much of a market economist or how much of a capitalist you are, right? Like a water divining rod is not a water divining rod just because someone sold you one as such, right? So like that's, I don't know, that's like glib argument number one. All right. Here's something like a little more nuanced than that, right? It's valuable not because of the information itself, but because its ability to serve as both an identifier, right? Like, this identifies a specific person, and because we know who the specific person is, we can identify other traits about this person, right? But also in some cases, a causal explanation for some of the other secondary identifiers that you're seeing, right? You've used genomic information to identify a specific person, and this specific person has a mutation, and this person has cancer, and therefore we think this mutation causes cancer, right? I mean, like, that's essentially where its value lies. And if you spin this out enough, in theory, you may be able to do other commercially valuable things with that information. You may be able to develop a drug, for example, that targets a particular mutation in a particular type of cancer. You may be able to predict, for example, whether or not someone is going to experience some condition late in life, or whether or not they have some enzyme deficiencies such that they shouldn't take a particular drug. And you could sell people stuff based on that, right? Like in theory, that's what makes it valuable. But I think once more, like with some feeling, right? I think maybe what this instructs us, right, is like the underlying information itself, which we view as like difficult to get and expensive and really telling about the things that like I just don't think any of that's true. Like is anything on earth that important that costs $299? Seriously, I don't think so, right? So I think this is informative of, I think this is like informative. I don't want to say this is like watertight by any stretch of the imagination, right? And part of this talk was to pretend like it's watertight because it's fun, right? But like I think this is informative about like what the value of this information is, right? To be clear, this is $299 retail. This includes shipping. You know, I think ultimately it's like nothing. Or how about this? This is like another really, all right. So this was fun doing this research, right? Like it used to be the case, like if you were doing breeding, if you were doing genetic breeding work, and especially for like racehorses, like super important stuff, right? People spent gobs of money doing sequencing and building family trees and stuff like that. This used to be the world, right? You're willing to pay stud fees in the breeding business, they'll do this, they'll give the information away, they'll do the sequencing for nothing, right? It's such a dramatic change. I think that's instructive about at least the vector of the value of this information going forward. Anyway, all right, there you go. Thanks.